insurance industry, or specifically insurers, is one of the most regulated commercial entities. This is due to its unique role and impact on society. The problem of insurance fraud has been growing in recent decades, but at the same time, insurance companies appear unaffected by the problem with stable profits each year. A number of studies have different estimates on the amount of insurance fraud, but it shows a relevant and tremendous increase on the real data reported. In Malaysia, there have been many insurance fraud cases reported during the last few decades, but no official estimates have been calculated by any authorities or governmental bodies. Under this report, it was conducted under Section 141 of Insurance Act 1996, Assumption of Risk, which is no licensed general insurer shall assume any risk in respect of such description of general policy as may be prescribed unless and until the premium payable is received by the general insurer in such manner and within such time as may be prescribed.
5 facts about this case. The first fact, on 9 April 1985, the appellant has entered into a hire purchase agreement with the plaintiff to finance the purchase of a vehicle. The second fact, the vehicle at the material time was insured by East West Insurance. The third fact, sometime in September 1985, the vehicles was involved in a self-accident. The fourth fact, while the vehicles was in the workshop, the appellants took out a comprehensive insurance policy, and in the proposal form, the appellants state that there was no past nor present insurance taken, and the vehicle has not been involved in any accident before. The last fact, the vehicle has been stolen, and the appellants lodged a claims against the respondent, but the respondent avoided the contract because of non-disclosure of material facts.
In Tung, Thian, and Anor v. United Oriental Assurance Sendirian Berhad is a corporation policy which obtained a sub-agent of the insurer authorizer by the agent. The vehicle was actually get stolen by someone. There was serious mispresentations in the proposal form which filled by all the sub-agents of the insurance authorizers. Okay, my second point will be, it clearly shows that the point is insurer who accept the employee of sub-agents by its authorized agent can actually pay an unauthorized agent. So the main point here was the agent was unauthorized agent. Now I would like to move to my third point. My third point is under Section 141 of the Insurance Act 1996, which is deal with general terms of insurance, shows that the receipt of premium which was received by the person who was not the authority to receive the premium lies with the insurers. The insurance also have proved that the agent is not authorized. The case also proved that the premium which received by the person who is not authorized in this case does not have any kind of premiums lies from insurer in insurance. My last point will be, the issue of the cases can be concluded as the agent should be authorized in the case to the law. The practice of insurers rely on and accept the agent procedures of new cases or business. The subsequentials rejects claims on the basis that the agent were not authorized to anyone or anything in the insurance cases.
Assalamualaikum warahmatullahi wabarakatuh. My name is NURUL IZZATI binti JAMIL and my metric number is 050750. So I will present about the decision of the cases. In Tang Thian and Anor versus United Oriental Assurance Sendirian Berhad 1999, the decision of the cases is Based on the whole evidence and the same cases that considered by these cases, the previous judge had dismissed the cases because the appellant had failed to submit the proof to strengthen his claim. So Muhammad Kamil Awang J, the judges of High Court, uphold the decision that was made by previous judge and also dismissed the appeal, and the appellant was liable for the cost.
According to the case, he has been revealed that this is the case under Section 141 of the Insurance Act 1996, and this applied to the risk assumption that could be made by the insurance provider. On the basis of the fact, the appellant have breached the agreement for non-disclosure of relevant information. The non-disclosure of the material fact make the insurance provider duty to refuse the contract. The High Court wrote that because the sub-agent was not appointed as an agent, the knowledge of the agent could not have been assumed be the knowledge of the insured. The whole judgment did not take into the account the industrial practice of allowing sub-agent to be used, in particular in motor insurance. Clearly, this raised the question of whether an insured who allowed the job of sub-agents but its approved agent can consequently raise the problem of sub-agent becoming unauthorized agents.